That's why I was. Oh, I guess we are on the air. Sorry. I will call the meeting to order. This is the Board of Appeals meeting for October 15th at 6:30. Would everyone please stand for the Pledge of Allegiance? I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have name tags in front, so I'm not sure there's a real need to introduce the members. But we have Pat, Ernie, myself, and Ashton. Brad is not here at this time. So before we get started, we do have to approve the minutes as well, but we have a fairly full agenda, which this board, since I've been on it, and I think I've been on it about 2.5 years now, we've had one appeal per meeting. So because they're interrelated, like Mr. Savinsky, right, mentioned, I agreed to put them on the agenda because we're going to be hearing the same kind of information twice. But I've told the board members, and I've committed that 8:30, we're not going to be here all night. I mean, it's probably going to, if we get to 8:30, we're probably going to be almost overwhelmed at that point in time after hearing more than one appeal and trying to sort through each one. So if we're at number 2, we'll do our best to finish number 2, and we'll have to discuss amongst the board and the people here when a convenient time would be to meet for the whatever's remaining on the agenda. So I just wanted to let everyone know that, just so that no one's caught off guard. Okay, so we've introduced the board members. We do have the minutes of September 10th that have been provided to us. If you've got a chance to look at it. James, you around? Where? Oh, sorry, you're way in the back. We need to change the vote on the back page to 4-0. And I'm looking at the, and I know I already approved, I kind of gave you a heads up that I thought they were okay, but I'm looking at the line that says, to achieve a resolution, the board discussed directing the staff to draft a letter. I think I'd like to add to Attorney Savinsky stating that the appeal of May 28, 2025 will be on the agenda for October 15, 2025. So it's clear what we talked about if the board has no problems with adding that to the minutes. That would be on the second paragraph under other business. The last sentence says, to achieve a resolution, the board discussed directing the staff to draft a letter, but it doesn't really state what the letter we're drafting was to entail. Any other questions, comments? We all set?
I have no comments
All right.
on the minutes.
Do we have a motion to accept the minutes as amended?
I'd like to make a motion to accept the minutes as amended, the added information.
I second.
There's a motion and a second. Any further discussion? All those in favor? Motion carries 4-0. Okay. That gets us to new business. And Mr. Savitsky, right, had mentioned taking these out of turn. I guess I'm interested in seeing what the board's preference is on that before we proceed.
I'm not overly concerned in the order of which they present their
Which
stuff.
they present.
I'm not sure that it makes any big difference.
Well, I was wondering about, in the minutes from the last time, it said the applicant's position is that the variance should be heard first. So I don't know if the applicant has changed their opinion.
That's a good question. Does someone want to speak to the applicant wanted to have the variance heard first?
You know, it really, it makes no huge difference to us either way. You know, that was probably, I think I was probably answering on behalf of these guys when I made that request, but I since filed another appeal for a different property owners. So,
Spend some time. It's fine.
Okay.
So
we-
they're here for the same issue, so I thought we might, you know, everyone's here in the room together, if we could tackle that issue first.
And-
But it's up to the board.
And, James, when someone's speaking in the audience, can we see or do we need someone them to come up to the podium?
Yeah, they should come to the podium and
Yeah.
and introduce themselves, yeah.
Oh,
No, that was my fault. I should have mentioned it. That was Mr. Savitsky mentioning that, you know, stating that's who was talking, just for everyone to know. You okay?
Yeah, as long as they're all set.
As long as you're all set? Okay, we're going to let you have the floor, and
Okay.
we're going to, I guess, well, when you get up here, you can explain where you want to head with this. How's
Okay.
that sound?
all right, that sounds great. Thanks very much. Joe Savitsky, I'm here from Perkins Thompson in Portland. I'm here on behalf of two applicants tonight, Streamline Structures LLP and Anderson Merrifield LLC. These are two related appeals involving the same provision in the Berwick ordinance. I've got a presentation queued up that I guess I need to go over here to get on the screen.
Let's, before we cue that up,
Yep.
so the board remembers, we met on, and now I got to get my notes out here, on May 28th of 2025, and held a hearing for the Birchcroft Lane appeal that's up there, lots 2-4, 4-2, and 4-3. At that time, we had some questions, and the lawyer drafted a letter that you all have for June 16th to address the questions that we had at the meeting on the 28th. We've never had a chance to discuss those with the lawyer because we haven't met under this appeal since then, so there may be some questions on that. We did table it at that meeting to get these answers, or I guess we got some we asked for some answers from the lawyer, and then after that, the appellant asked for it to be tabled, and so we're here at this point in time with the continuation of the meeting of May 28th. In the meantime, like the lawyer mentioned, we have another appeal over basically the same 7.21 in our ordinance, and so it seemed beneficial to do those at the same time if we can manage to work our way through that. Everyone all set on what I just said? Did I make any errors?
Could I just ask a couple of clarifying questions, Mr. Chair?
Absolutely.
And I'm Grady Burns. I'm your town attorney for the evening from Bernstein Sure. I believe we've met. I was at one of the last meetings you had, but I'm here tonight to assist you and advise you. And on the other side of this, potentially help you draft up findings and conclusions for any of these appeals or variance appeals that we get through tonight or at a later date. Just as a couple of preliminary matters, I know that the Birchcroft appeal, as you said, Mr. Chair, there had been a previous meeting where you had done some preliminary review of this. Did you go through any, at that time, questions about timing and jurisdiction, just preliminary, making sure that we're here, that you have jurisdiction, you have a
Yes.
quorum, those preliminary pieces?
We did determine that we had jurisdiction because it was 7.21 out of the ordinance, so that has been established, yes.
Excellent. All right. I just want to make sure that we got
Nope.
the kind of the procedural stuff
Nope, I
out of the way.
appreciate that.
And then the only other thing, so it looks like we're dealing with Birchcroft first. I would just want to pose to the board to talk through if there's any conflict of interest or bias issues that need to be disclosed prior to getting into the merits here as well.
As far as I know, we addressed it at the last meeting. I don't think anything has changed since that meeting. No one's bought property on Birchcroft Lane or anything?
Nope.
All right, so I guess we're okay to proceed.
Excellent. Thank you, Mr. Chair.
Okay.
All right, I guess
You ready?
you're up
Okay.
now.
Okay, great. Thanks very much. Okay, if I just stay here so I can
Yes.
flip through the presentation, great. Let me just refresh the board's memory just a little bit. So these are two lots, labeled 4-2 and 4-3 on map R15. Here is a survey depicting where these lots are. Here's 2 and here's 3, and this is a subdivision, or a survey that was recorded in the registry in 1987. So these have been lots of record since at least 1987. 2.46 acres each with about, looks like 335 feet of frontage along this 50-foot right-of-way that has been reserved to provide access to these two lots. Conforming as to lot size and frontage under the ordinance, so there's no concern about these being non-conforming lots. There was a letter from the town attorney that answered the question with respect to if these lots were non-conforming, would the access requirements apply? But as far as I can tell, these are conforming in terms of the lot area, frontage, that type of thing. So this right-of-way is towards the end of Birchcroft Lane. Birchcroft Lane is a private road. Let me see if I can go a little further here. All right. So here's Birchcroft Lane. I forget the name of the street that it ultimately connects.
Little River Road. Little River.
Little River Road. So all the way down here towards the end, and then you've got these two lots here, 2 and 3. So Birchcroft Lane has been in existence for decades. It's a private road. There's a road association that's been established to govern the maintenance and repair and upkeep of the road. And these two lots are accessible via towards the end of Birchcroft. About 4,000 feet, I think, is the total length of Birchcroft Lane. So here's the provision that we're here to discuss tonight. It's actually been amended since we filed this appeal. I think this would be the provision that, since this was the version of the provision that was on record when we filed the appeal. I think this would be the one that would govern this appeal. I don't know if frankly, the revisions that occurred in June of this year, to me, just further confuse the meaning of this provision. So I don't know if it's relevant, which version of the provision is relevant, or if it matters. But you've got, all it says is 7.21, access to lots. And then you've got a chart with a column for dwelling units and then the standards that apply. And then you've got a different standard depending on if it's one dwelling unit, two dwelling units, or three or more dwelling units. It doesn't say, there is no mandatory language that you might expect, new lots shall be constructed in conformance with section 7.21. It's just a table, and what you see is what you get. So I think the confusion surrounds what's embedded in a note in the bottom of the table, which says drainage ditches and culverts shall be installed at all appropriate points as determined by the town of Berwick or a third-party engineer hired by the town. So there it uses the word shall, that's a mandatory requirement. And then it just says access to lots refers to any streets, roads, or right-of-ways utilized to access the lot. So I think that's the source of the confusion in this particular provision is, what does that mean? Access to lots. And the building permits that were denied by the CEO were denied on the basis that Birchcroft Lane, and as I understand it, the entirety of Birchcroft Lane would have to be brought up to town of Berwick road construction standards in order for building permits to be issued with respect to those two lots. So that's a prohibitive expense. In our variance application, I got into a little bit of the numbers behind what it would take to do that. Over $1 million, which combined with construction costs to acquire the lots, site work, utilities, etc. We're talking about a total of investment of about $2 million for two modest single-family homes. So to recoup your investment on that, you'd need to sell these homes for over $1 million a piece. That's not really what the market is down in Berwick. That's a pretty good price for a house anywhere in Maine, and not what these guys were here to do. We've got a mock-up of, it's a simple 3-bedroom, 2-bath, single-family home, great starter home, great family home, or for empty nesters, whatever. Pretty simple development project that really rendered economically unfeasible by a potential requirement to upgrade this entire road to town standards. So it's interesting it references the road construction standards. Those are also embedded in a link in the ordinance, and if you pull them up and you refer to them, they're in the packet. They're in your packet, but under general information, sort of the opening provisions of the road construction standards, they read, for a private road to be upgraded for submission to the voters for acceptance as a town way, or for a new road to be constructed for submission to the voters for acceptance as a town way, the following minimum standards listed below must be met. So I think the intent behind the road construction standards is for new roads or roads that are looking to be upgraded to town standards, so and would be offered to the town to accept as a public way. And that makes total sense if the town is going to assume maintenance responsibility for that road. You want it built to the town standards, and it wouldn't make sense for the town to agree to maintain a road that was not brought up to the standards. But that's not what the applicants here are asking. This is a private road that's got a road association that's been in existence for years. And it's the road association that's been responsible for the maintenance of Birchcroft Lane. And that remains the case, and there's no intention that I'm aware of to ever change that. And if there were, then I think the town would be totally within its rights to say, well, you got to bring it up to the town standards before we accept it as a public road. Makes total sense. It doesn't make sense to require these two lot owners, which derive access through a reserved 50-foot right-of-way, to upgrade this entire 4,000 square foot length of road to road standards, just to put two houses there. This is a residential neighborhood. It's R3 zone. Very few uses are permitted in the R3 zone without, a bunch are permitted with conditional use permits. Those are subject to, intense performance standards. This is really meant to be a residential zone. And if you were imposing a requirement to upgrade an entire road to a public townway standard, where the road is not even intended to be a public or townway, it renders the cost to develop these lots as really totally economically unfeasible and frankly unbuildable, because no one's going to be able to undertake that expense just to put two houses in. I think also there's some language in the ordinance, and I think the provision is vague, but there's some language in the ordinance that I think suggests it wouldn't apply to a road that doesn't directly provide the frontage for the lots of question. So access, for example, is not defined. Access road is defined, and that's defined as a right-of-way. It says C right-of-way. A right-of-way is defined as an area or strip of land at least 50 feet in width, described in a deed and dedicated to the purpose of providing access to the parcel or parcels of land abutting it. So I think that the concept of access to lots and the requirement in 7.21 of access, if it applies at all, it's only going to apply to what access road or right-of-way provides the legal access to the lot, which is not Birchcroft Lane. It's the 50-foot right-of-way that's been reserved, was reserved back in 1987 to provide access to these lots. And just as a reminder, so this lot 401 there's a single-family home there. It's been there for years. The driveway's on Birchcroft Lane. So this 50-foot right-of-way really only provides access to these two lots, and that's it. So for all these reasons, we think that this particular requirement does not apply to lot 4.3 and 4.2 and 4.3. If it applies at all, it would only apply to the 50-foot right-of-way, not the entirety of Birchcroft Lane. So happy to take any questions.
The concern I have with your argument is, I think we have Arlene Lane that's right down there, right beside.
Right here?
Yes.
Yeah.
So I decide to subdivide that 22 acres out there, and I come in and I say, well, unfortunately, this argument probably doesn't hold water because it's already permitted to have two lots on there right now. But say that there wasn't two lots permitted on that lot. You could put a road off Arlene Lane and now that's a third road. I mean, I guess where I'm trying to go is, how many spurs can we put off a dirt road and have it be okay? We only have to pave the spur we put on. Does that make any sense?
Yep, I understand the concern. But we're not here to talk about Arlene Lane or any future lots that might be
But this,
developed off of Arlene Lane.
our
We're talking-
decision
yeah.
will, in effect, open up Pandora's box that anyone that wants to use the finding of facts we're gonna find here at this meeting,
Mhm.
and now we'll be able to start adding roads off other roads with the decision that we're gonna make tonight. If we make that decision, when we make that decision.
To speak to, these are existing, that are, so if Arlene Lane is added to, that's new lots going down, new ones. I'm looking at 721 here, and I would like to ask you, on 721 above A, I guess, under the table, if you want to get to page 67.
Mhm.
How does more than 2 dwelling units may be allowed on a discontinued road for those lots created prior to March 14th, 87? And it's, this survey that is in his packet here, it's March 13th, 87, so it's prior. Does this not apply? I know this is discontinued road. Discontinued road would be a road the town owned at one point, and then they relinquished it, or relinquished care of it.
Right.
So does that knock them out from, the fact that they are from before March 14th, 1987? Does that knock them out from using, because it says it's discontinued road, why can't they get the build based on this paragraph there?
So I think you're asking a good question. Part of your job is to interpret, apply your own interpretation of the ordinances to the facts that you see. So I can help talk through kind of the tools of how you would do that. But to the specific question here, as you point out, that provision does say more than 2 dwelling units may be allowed on a discontinued road for those lots created prior to March 14th, 1987, provided that the road is brought up to the standards for 2 dwelling units as described above. I think one of the first things that you have to do whenever you interpret an ordinance is to try to give meaning to each word. So we do have the word discontinued here, modifying road. To my eye, I think the most reasonable way to look at that would be, we're talking about a specific subset of roads, those that are discontinued, and we're looking at lots that were created prior to March 14th, 1987. So that's it's a form of a grandfathering provision.
Mm-hmm.
But by its terms, I would say the easiest way to read that would be that it's applying to dwelling units that are using a discontinued road for their access.
Not a private road.
That's the amendment that just went into effect in June that you're quoting there.
Mm-hmm.
So that was actually not in effect. A prior version of this provision was in effect when we filed this deal.
Mm-hmm.
I don't know that it's
And also presumably when you filed for the building permit application.
correct.
Yeah.
Yeah. More importantly, yes.
Yeah.
That. I don't view it as.
Can I,
Sure.
James, can you clarify that? I was under the impression that was not changed. That was,
James Bellissimo, town planner, that was in effect. The discontinued road provision was amended to allow an additional one, and it cleaned up some language that would allow a third unit as long as it had like A, B, C, D, E, F. We got rid of that part.
Okay.
So the allowing more than 1 dwelling unit on a discontinued road was in existence already.
that's what I,
So can I ask a clarifying question about versions here?
Yes.
So the version of the ordinance that I have currently is, on the front of it says amended June 10th, 2025, and it was pulled off of the town's website. This version would be the one that incorporates
That's the most recent.
the new
Yes.
language?
Yeah.
Okay.
yes.
Do you all have a copy of the version that was in effect at the time that this application came in?
I did, but I don't think I do now. I think I
got rid of it.
replaced it with
Yeah.
the new one.
Okay. We want to make sure that we're all looking at the same version of the ordinance, and that it is the one that was in effect, when the relevant application was submitted. Mr. Stavisky, I don't know if you have a copy of that ordinance language.
I quoted the provision in the administrative appeal that I filed back in April, but it looks like I just quoted what I thought were the relevant provision, the relevant part of that section, and it might not have been the whole section. So the table is the same. The 7.21 access to lots with the 1, 2, and 3 dwelling units with a note below. That was all part of the same, and that's what I view as the relevant language to frankly both appeals here. It's interesting that the amendment or the 2025 version references a discontinued road, which is like a road that the town once held an interest in. To me, it gives further credence to the meaning of this provision is it's intended to apply to roads that the town is going to ultimately accept ownership of, not private roads. Another thing that came up too, and I almost forgot to mention, but it came up in the last meeting about this property, is the seller, and I believe you gentlemen as well were advised by the former CEO that this was a buildable lot, that were buildable lots and that met the requirements of the ordinance. And the seller was even provided a letter to that effect, and I submitted it. It should be in your materials. But basically,
I think you're going to find we don't have the paper copy of it. We got a form on the laptop. The
Okay.
only one we did receive was the new one because we didn't have the paper copy of that originally.
yeah, okay. So actually, this was a supplemental submission that I emailed to you, James, a week or so ago. Anyway, there's a letter from the former CEO to the seller, which provides an opinion as to lot 4.2. And I don't know why 4.3 wouldn't also be governed by the same opinion, but it says 4.2, quote, meets the requirements in the town of Berwick land use ordinance as a buildable lot for a single-family dwelling, end quote. So that's what the letter said.
Right.
So
Is that like a photocopy of the letter or something? We can
this
see?
is, I quoted from the letter. I thought it was going to be in your material, so I don't have extra copies of it. There's another letter here from, this is another letter from the seller stating the same thing, which I can provide. I'll get you do you have a copy of that letter? The letter from the CEO.
Paper, no, I do not.
Yeah.
I do have it in my email. If there's a printer around, I could get that for you.
Yeah.
And I do know that that letter did come in as a supplemental submission, I believe about a week ago.
Yeah, about a week ago. Yeah.
So there is an electronic copy that would be part of the record.
That was in your presentation too the last time you were here.
Good, yeah.
I remember it very
So anyway.
specifically.
There's a letter in the record.
Right. Unfortunately, it was the previous code officer, so we don't have the luxury of having the code officer stand up and,
Right.
and tell us the extent of why
Right.
that letter was written.
Right. Well, I think so. So Matt and Dan here bought these two lots in reliance on that opinion. So
Understand.
Can I just ask you a question quick?
Sure.
Would you stand up just so people can?
state my name.
Want to make sure we catch you on the mic.
My name is Matthew Gates. I'm one of the owners of Streamline Structures. So when we received that letter from the seller, it was from the town stating this is a buildable lot. I don't really know why I would think otherwise, and it was signed by the code inspector. So I guess I just ask that, put yourself in our shoes. If you were provided this letter and somebody said, I'll sell you this land, if you're a developer, of course, you're going to buy that land and try to build on it. And to me, it's a document from the town. So it should hold some weight.
The dilemma, just so that you're aware, and the lawyer will probably correct me if I'm wrong, because I probably am at times. The dilemma that we have is we have to follow the ordinance. Superior Court can probably make a decision that, based on all the facts that you present, that you deserve to have a permit. I'm not saying we're not going to grant you that, but we have to follow the guidance here in this ordinance. Even though the town said you could build, then they said you couldn't. That's part of the record, but it's going to get down to whether we have the authority to do this within the ordinance. Does that make sense?
Yes, fair enough. Thank you.
That's an excellent point, Mr. Chair, and I guess what I would say is that this particular provision is vague and susceptible to different interpretations, and I think it's a reasonable interpretation to conclude that this applies to new roads that are being constructed to be offered to the town for acceptance as townways. Makes total sense that the town would require that of a road that they're going to ultimately accept ownership of. But that's not the case with Birchcroft Lane or the 50-foot right-of-way that provides access to these two lots.
So in the previous meeting, a question came up, which I think Ashton's worked his way through, and the board had, were these grandfathered conforming lots? And I believe that the date March 14th, 1987 gives us some sense that if a discontinued road was grandfathered then any lot would be grandfathered then that's using this 7.21. Is that a fair assumption to make?
So I know that my colleague Phil Saucier provided a memo to the board that addresses, I think, in part that question back on June 16th, 2025. So he notes in his memo that Section 7.21 outlines the road standards that must be met depending on the number of dwelling units for access to lots. Under that section, if there are 3 or more dwelling units, the road must meet the Town of Berwick road construction standards. Under this section, the term access to lots refers to any street, et cetera. We've discussed that language. He notes that there are no exceptions to those standards other than to allow for up to 2 dwelling units to be allowed on a discontinued street, provided that the road is brought up to the standards for 2 dwelling units as described above. His conclusion was that while a vacant, legally non-conforming lot may be built upon that does not meet the frontage requirement, it must still have legal access to that lot. It is simply exempt from the linear measurement requirement calculated by the distance along the property line that borders the access road, i.e. frontage. In other words, frontage and access are 2 separate standards that must be met. So I think that was that opinion was trying to get to, I think, part of that question, what would the effect of these lots being grandfathered have on the question of what level of road construction would be necessary? And I think, I concur with my colleague's analysis there, that the non-conforming status it states that they may be built upon if they do not meet applicable area or frontage requirements, but all other dimensional standards must be met unless a variance is obtained under the town's ordinances. So I think the upshot here, or at least the conclusion as to that legal review, was that the non-conforming status of the lots themselves would not have a bearing necessarily on that question. It's a question about the road itself rather than the lots.
I think that non-conforming piece just throws an awful lot of confusion in, because these are conforming lots and they're grandfathered lots. So I think it really gets down to, from my interpretation of, when it says a discontinued road is grandfathered in 1987, to me, then that means any conforming lot is grandfathered in 1987. Whether they can meet the standard because of the discontinued road, but I think we have, in my mind, we've got two grandfathered conforming lots, like Mr.
Yes.
Savinsky said. So I don't want to just take the non-conforming piece out, because I think it's, unless I'm missing something, that's just throwing more confusion into the mix.
So my understanding from the applicant is that the lots are in fact conforming as to their size and their frontage. Is that
Correct.
Correct. Okay.
Yeah.
So whether they would qualify as non-conforming lots under the ordinance, I think is potentially a separate question here. I think the applicant is trying to point you to the provision contained in the table, and is making the argument that under that language, the best interpretation is that this road is not required to be brought up to the standards contained in the town's road construction standards, and has set out a few reasons and a few interpretive points as to why they think that that's the case.
Right.
Certainly, if you think that there is an alternative reason, you can explore that. But the burden here is on the applicant to demonstrate that an appeal should be granted here. So I would begin with those arguments in that language and see where that takes us before going too much farther afield.
I understand. Unfortunately, we've never had a chance to discuss this letter that we received, because we've never been in session since then. So I'm just trying to wrap my hands around the non-conforming piece and how that relates to anything. Just for my clarification, I understand that he hasn't brought it up per se, but I think it's important, at least for me, to know what the context of this letter is trying to tell me.
Absolutely.
So, where are we at right now?
Are you finished your presentation?
I'm finished for now, but happy to
Answer
take
questions.
more questions. Yeah.
I'm surprised that Mr. Saucy didn't speak to the discontinued road vice private road thing in this. Figured he would have, you think he would have said this doesn't apply because it's not a discontinued road, and he didn't speak to that whatsoever that I see. I don't think it's a coincidence that the day before this came into effect, they got it administratively figured out ahead of time before this stuff went into the new law into effect, and now the time's come when it's going to use it. Ended up being 40 years, but
The timing is very interesting, that this says March 14th, 1987, and this was recorded in the registry at March 13th,
Yep.
1987.
I imagine there's a lot of deeds in Berwick
Yeah.
that are the same. There's a lot of surveys, not deeds. I don't know I didn't get to see the deed, but I bet there's a lot of surveys that before this went into effect, they tried to lock in their stuff so that down the road it wouldn't be a problem.
Yeah.
So I do think, based on the language of of this provision, I think the board, if you are trying to apply that language to the case here, I think the board does have to grapple with this question of discontinued road, and how that may or may not be applicable to this case. A discontinued road does mean a specific thing. I'm not sure. I don't believe it's defined in your ordinance, but certainly there is a process for discontinuation, as you mentioned earlier, that is generally referring to roads that were town-owned roads, where the town then relinquished its claim to those roads, possibly retained an easement. But those roads were at one time roads that the town was responsible for maintenance and upkeep for. So they are a specific category of roads, and this provision does include language that I think is pointing specifically to that class of roads. So if we're talking about a discontinued road here, then I would say potentially this language could be significant here. My understanding, based on the presentation, is that Birchcroft has always been a private road, and at no point was a public road. That's my understanding. I don't know if that is factually correct.
I don't know if the same wasn't intended for the 50-foot right-of-way, though. I don't know the answer with respect to Birchcroft Lane, but the 50-foot right-of-way appears to have been created effective March 13th, 1987.
Was it ever offered up to the town, or was it ever a public way?
I certainly don't think the town ever accepted it, but by virtue of it being recorded in the registry, if there was some that.
It was never public. It was never offered to the town.
So again, I think these are factors that might be relevant in that analysis, and certainly, the board has had some discussion of that provision. It's worthwhile to talk through whether or not that language might be operative here. I think part of that would be determining whether or not any of the subject access ways, whether it's Birchcroft or the access way. I think part of the appellant's argument here is that really we should be looking at that access way and not Birchcroft proper. So I think, answering the question as a matter of fact, whether either of those were town roads or town ways previously and then were discontinued, I think would be relevant. Again, though, the interpretation of that provision, that's your guys' job. You can ask me how, to help you out with giving you those tools, but that determination it rests with you.
I think once a road is discontinued, what's the difference between it and a private road? Once the town lets go of it, now the people that live on it have to take care of it like a private road. It's that's the way I see it.
So there can be some legal differences when a road is discontinued. Generally, an easement is retained in that road. A public easement is retained in that road, and sometimes it's not, though, and it fully reverts back to the property owners. But again, the significance of that is something that you guys that you would have to weigh. But that would be the only legal difference, is potentially there may be a public easement retained in a discontinued road after it's discontinued.
Right, so anyone can pass it.
They would have the right to travel on it.
Yeah.
Yeah.
So, yeah.
Can we kind of clear this up by asking James if this was ever a discontinued road?
Okay. Yep. To my knowledge, no, this was never a town-owned road. I think it's been a private road the whole time.
Okay.
Birchcroft Lane.
Birchcroft. Yep.
Not the. Yep.
Thank you.
You're
So
welcome.
it's not a discontinued road.
Correct. Private road.
A further thought, if I may.
Yes.
The dispute here really isn't
No,
with respect to the 50-foot
it's not.
right-of-way, because there are only two lots, 2 and 3, that derive access from that right-of-way. The dispute here is about, can this access requirement in the ordinance require the owner of lot 2 and 3 to bring the entirety of Birchcroft Lane, which does not create the frontage for those two lots? Can the town require the owner of those two lots to upgrade the entire length of Birchcroft Lane to town lot standards?
Right.
And we say no. I don't think that's what the ordinance provides.
And we don't plan to try to turn Birchcroft Lane over to the town? No?
It's cost prohibitive.
Any further questions?
Of him?
Yes,
And certainly you can call him back up if you do have
Right,
additional
exactly.
questions.
I think we're all set.
Okay, thank you.
Does anyone else wish to speak at this point in time?
I will say something if the members of the board are.
Come-
Yeah, just come up to the podium, please.
My name's Kate Boyle. I'm a resident of Birchcroft Lane. I also am on the board of the Road Association. I wanted to thank James first because we did bring up an issue that I hope will continue in any future issues of this nature, which is that the actual physical abutters of this property, or these properties, were made aware of this situation, but we as the Road Association were not in an official manner. We, of course, found out about it because some of those physical abutters are also on the board and active members of our association. But as the basically legal owners, if you will, of the entirety of the right-of-way of Birchcroft Lane, and also those who are financially responsible for maintaining it, we are a very relevant party in this conversation. We also have all been very aware of the fact that those two lots were not considered buildable. At least I can speak for the, I think, 10 years that I've lived there. I do know that you guys received that letter, and that is incredibly confusing, and I feel for you as somebody who is married to a developer or contractor. I think this is an incredibly confusing situation. I'm going to be super honest and speak as myself and not our road association right now. I don't even fall on either side of this. I don't think it will necessarily affect the nature of our locality and our neighborhood if two modest homes are what are installed. My concern, and this goes to everyone, code enforcement appeals for the future, is there are over 160 private roads in this town. As you know, there are two issues in this room right now. And this could set a precedent that could have a lot of effects on a lot of people. And the reality is we know that we cannot bring our town up to road standards because I had actually already estimated over $2 million for that cost. And the other thing that's happening right now is another lot on Arlene was just purchased. I don't even know the names of the owners yet. It just happened. And I know that after telling the real estate agent in charge of that listing, which was probate, so it was confusing, I informed them that their listing was misleading because that listing stated, investors take note, possible subdivision location. As we know, it is not a possible subdivision location. They would have to bring the entirety of Birchcroft Lane and the entirety of Arlene Lane up to town road standards. The real estate agent decided not to change anything about the language of that because I guess technically you could do that. But I believe, and I'd love clarification, and please tell me if you know outright that I'm wrong, we would need to be consulted before that construction happened because the road association is responsible for and owns, I believe, in technicality, the road, because the town does not. And we would need to be asked before somebody did that level of construction, meaning adding culverts. There would need to be about 13 culverts, if my count is correct, added. So every driveway off of Birchcroft Lane as well as a couple of other key locations, and then all of the paving. Do you have a clarifying
So
question?
I'm 100% everything. I think that's very stuff I would want to be asking too if I was you. But I think that what you should do is a planning board meeting and bring that up.
Sure.
Maybe that's where you would want to get that out there.
Okay.
I think
Absolutely. So then I'll just say what's specifically relevant to this, which is I super feel for you. I do hope that this is a big lesson in due diligence. And the unfortunate thing is, had you come to any of us on the board, we would have explained that this is going to be a long road and that there are a lot of complications, and that code enforcement officer that wrote that letter was in place for a very short amount of time. And unfortunately, the seller of that lot knew that, and that's why he went and got that letter. So,
You all set?
yes,
Thank you.
thank you.
Thank you. Did you need to speak about anything?
So I was just going to say, members of the public, so I think we've already opened up to members of the public.
I apologize. You should have said a chance.
The town as well. So the code enforcement office, as the ones who kind of made the decision before you, they are the appellees in this matter. So if they have any comment, presentation,
Sure.
additional evidence that they would want to submit, they should have an opportunity to do
Yes.
that
Thank
as
you.
well. It's your meeting. The order can be.
Well, we
you
do
do
have
have some
bylaws
procedures
that we
in
kind of-
your
yeah.
provisions here. Not to rewind too far, but I would recommend that we check in with
The town.
and
Yes.
see if they have anything to
I
say.
think that's a good idea.
I'd like to speak briefly.
Let's let the town,
Oh.
we're kind of out of order here. I think let's let the town come up and,
I just got a couple of things, and I'll turn it over to Terry. I just wanted to emphasize on 7.21, it does refer to access to lot, refers to any streets, roads, right-of-ways, utilize to access the lot. So I think that speaks pretty plainly to Arlene and Birchcroft being together in the access from Little River Road. And then I'll speak to the intent of 7.21. I've been with the town for 9 years. Access to lots has been a confounding issue for our community going back those 9 years. I mean, we deal with this on a week-to-week basis of what does 7.21 mean. So we had it in a paragraph form. We switched it to a table form that seemed to help out a lot. But it always had that reference to the town of Berwick road construction standards. And if you look back into the files and correspondence with attorneys going back 30 some odd years, 20 some odd years, there's been a very consistent interpretation that, ties the ordinance to those road construction standards. So, and I totally understand that the road construction standards document is confusing, and that actually was amended in May. The road construction standards document was updated to clarify that also it always did apply. And if you look back through the consistent interpretations with attorneys and staff, that it always did apply, but that was updated to clarify that it applies to 7.21.
in the ordinance,
Yeah,
it was updated, the ordinance.
in the
was
road
updated-
construction standards.
Oh, the road construction standard.
The road construction standards was updated in May to add language to tie back to 7.21.
So we don't have
Yeah, that's not the most.
We don't have the most
one, yeah.
up to date. Plus, I guess we're going to go back to if it's in May, this is already on the docket at that point in
That's
time.
Yeah,
I have a question
Yep.
of you.
sure.
You said that the road standards and the lawyers and everyone have agreed over the years with have agreed with the interpretation or come up with a similar interpretation.
Yep.
I was wondering if, I assume many times this has also come up as not just the road standards, but as the issue that we're dealing with now. And I wondered how, has that had a consistent, I don't know if you've researched that or not.
Yeah,
If that has had a consistent,
yeah, with right-of-ways off right-of-ways, that's been, that's consistent. We count, so if you have a street and you have another street off a street, then we would consider that as one accessing back to the main town street.
and so I think one thing that seems to be a little confusing here is that I think the reference needs to go back to a town road, like Little River Road, for example, so that when you have a dirt road off Little River Road, a town road, then this is the kind of stuff that starts dealing, okay? And so now we're talking about dwelling units not off a town road. So
Yeah,
I think,
it's off a private right-of-way.
right, but
Yeah.
I think that's, to me, a lot of the confusion, because we need to be going, these go, if I'm not mistaken, these go to, you have to go back to the town road and work off the town road. And so there are lots of houses on Birchcroft Lane, but, you know, and that isn't our concern tonight, but it seems like if 3 or more dwellings are on a dirt road off a main town, off a town road, then they need to be upgraded. Is that correct?
Yeah.
So that's why I think the code enforcement keeps shoving everyone back, because your base road that you're talking about is Little River Road. And I think other people think that the base road is Birchcroft Lane. And I know from the history of when this was all done, you know, this was done exactly why, you know, the town was, this was done to keep all of this from happening, and happening again on West Meadows, and happening again on all the other roads. And I think that that's kind of missing in here, that it starts on the town road. And I think what I'm asking is that the history, that it starts on the town road and works from there?
Yes. I mean, yeah, I think if you look back through, for the prior of it being amended, that it speaks to a private right-of-way. That's, you start with a private right-of-way off a street. That's what Birchcroft Lane was.
Right.
Private right-of-way that
And
became.
so 3 or more dwellings on that private lane
Right.
should have been upgraded a long time ago?
Yeah.
or-
Yeah, except, you know,
Except for a variety of reasons.
yeah, Birchcroft was all
But-
pre-zoning for the most
Yes,
part, yeah.
yes. But I think that's why you can't forget that that's where we're starting from and coming, is that it has to come from Little River Road. So to me,
That's the town's position.
the town road.
Yep.
Okay, thank you for clarifying
Yeah, I
that.
think I'm done my part.
Okay. Terry, did you want to speak?
Hello, my name is Terry Wilson. I'm the code enforcement officer. In regards to the 2 lots off of Birchcroft, when reviewing any permit applications, I apply our land use ordinance, the access to lots 7.21. I did apply it in this case. To me, access to lots refers to all the roads that are necessary to be traveled in order to access the lot. So based on our land use ordinance, I did deny the building permit applications without the road being upgraded to town road standards. So that is how I made my decision. I try to apply the same uniformity to all of my decisions. Unfortunately, every once in a while, something gets past me. I'm very busy, but I do my best in applying evenly and fairly the land use ordinance to all of the permit applications that come before me.
And basically, you're confirming what James had mentioned and Pat was talking about, that you would be using Little River Road as the road,
Yes.
as the town road that something is coming off of.
The private right-of-way does access the lots, but to get to that private right-of-way, you need to utilize Birchcroft. So, yes. Did you have any other questions for me? No? Okay.
What do you think?
So, we've heard from the appellant, we've heard from the town. We had one member of the public who has spoken. I would recommend that you see if there are any other members of the public who are in attendance who would like to speak to any of the issues. From there, generally, I would recommend giving the appellant one more chance to address anything that was
Discussions
raised.
that have come up?
And then you can ask any additional questions from there. And if there aren't any, we can close the public hearing and go to discussion.
They should probably open the public hearing.
That too.
Anyone else from the public that has any comment, please try to keep it relevant to the topic that we're talking about, the 7.21 access to the property. Are we all set? All right, would you like an opportunity?
Just briefly, Mr. Chair. I appreciate the comments from the Road Association, and it brings up an interesting point. I think it would require the Road Association's consent, at minimum consent. There's the deeds to these two lots have an access easement over Birchcroft Lane. But that in and of itself would not necessarily allow them to do the thing that the town is ordering them to do. So that's another reason why I feel like the provision is unreasonable, applying it to a road that you may or may not even have the right to do the thing that the town is requiring you to do.
Right.
And I understand the town's position and the town's interpretation of this particular provision in the ordinance. What I would say in response is, it says, access to lots refers to any streets, roads, or right-of-ways utilized to access the lot. Well, a street is actually a townway. These are all different, so this is not a mandatory language. It's in a note, and it says this is what we're referring to. It's entirely ambiguous to me, and it's being construed in a manner that is prejudicial to lot owners who bought these lots in reliance on the town officials' interpretation that these were buildable lots that met this particular requirement.
Right.
So that's all I had for the moment, unless there are further comments from the board. Questions?
All set? I guess we will close the public hearing.
One more for the lawyer.
No, go ahead.
So, like, back to the lots from 1987. Does the ordinance coming in to say, there's a few hundred of them that they got in before that deadline, and then the ordinance comes in the early 90s or, then the land use ordinance comes in, and then does that automatically make them all no longer, good lots? Isn't that the idea of something that's grandfathered in? It's prior to the ordinance, and you can't make everyone, now you have to do this because we changed the rule a decade later.
So a non-conforming lot is a lot that was lawfully in existence prior to the enactment of some subsequent ordinance that then makes it non-conforming. Right?
Does this make it lawful? What was the first term you said? Does this survey make it a legal one or whatever, since it was before that? I know we don't have the deed to look at, but.
So, if for example, these lots were created, anytime prior to prior to the enactment of the ordinance, then you would look at what was in effect at the time of the creation of the lot. When it became a lot of record is usually when we look at.
This is a lot of record on this. It says received,
And then,
registry of deed received.
So I'm just going to go to the town's own definitions here.
There was a lot of record then, once it was received, the stamp on here.
So a non-conforming lot of record under the town's ordinances is defined as a lot shown on a recorded plan or deed which does not meet the area, frontage, width, or depth requirements of the district in which it is located and was in lawful existence at the time this ordinance or other subsequent amendments took effect. So if you have a lot that was lawfully in existence but now does not meet one of
A
those...
non-conforming lot.
So it becomes non-conforming with the enactment of that subsequent ordinance, right?
Okay.
So at one time, it had to have been in lawful existence. When it was created, it had to have been in lawful
Okay,
existence.
yeah.
Otherwise, it's simply a non-conforming, unlawfully non-conforming lot, right? But the ordinance points you toward certain dimensional standards, so area, frontage, width, or depth requirements of the district in which it is located. So if the ordinance renders it nonconforming as to one of those things, then it becomes a nonconforming lot of record.
Because access isn't on that list. That's what you're saying?
It is not.
Doesn't list access, which that's our problem.
Right.
saying.
And so I think that's part of what Attorney Saucier was addressing in his own memorandum. But I think the first question would be, are these non-conforming lots of record? I think the appellants, not to speak for them, I think they've taken the position that these are in fact conforming lots. They
Yes, yep,
conform to
that's
the
clear.
town's dimensional requirements. So we would only be in the section of the ordinance dealing with what do you do with a non-conforming lot if they were actually lawfully non-conforming. So part of the analysis here might be, working through that question for yourselves as to whether these constitute lawfully non-conforming lots of record. I think the legal opinion that's been provided to you is pointing you toward that language, the specific standards that are called out here, and that access is not one of those, that it stands apart from the provisions that the non-conformity.
It's a different issue.
That's
over
right.
here. It's not one of those, yeah.
Yep. But you're free to. That's an opinion provided by your attorney ultimately, and by that same token, you've heard from the appellant and the appellee their own interpretations as to what this ordinance means or how it's been interpreted in the past. You can list. Those are things that you might listen to and might help inform how you yourselves interpret those provisions, but ultimately your job here is to interpret these ordinances yourselves and determine based on your own review what the best interpretation is. Same thing with questions of fact. One party may have one gloss on what actually transpired, another party may have another one. It's your job to credit the credibility of who's giving you that information, and based on the record before you, determine what happened, right? You're sitting in that role kind of like judges in this instance. And I think looks like Attorney Savitsky has some more he'd like to say.
Just real quickly on this non-conformity issue. These lots were created in 1987. They still meet the lot area and frontage requirements of the ordinance. I don't think there's any dispute about that. I did want to point out, though, this access to lots provision. It's my understanding, and I think this came up at the prior
meeting that we had back in May, is that this particular section, 7.21, access to lots, was adopted in 1988. So after these lots were created. So if you consider, in a sense, they're non-conforming with respect to the access to lots provision that was adopted after the lots were created. But they still meet the lot area and frontage of the current ordinance. So that's all.
Any further comments, questions? We'll close the public hearing. At this point in time, we'll go into discussion amongst ourselves. If we have any questions, we can call someone forward or ask our lawyer. But really now it's just between the four of us working through what we've heard and trying to come up to some understanding of where we're at.
Yeah, and before you, and I know, I think most of you have been, this is not your first rodeo, but just want to make sure that in terms of the scope of your review, you're clear on kind of what your remit is here. This is a de novo review, so you've heard testimony, you've received new evidence. You are essentially sitting in the shoes of the original permitting authority. You can take what the CEO and the town have said as evidence one way or another, but ultimately your job is to look at these issues like they're being looked at for the first time and determine whether or not a permit could issue based on the language of the ordinances. Now, you're doing that, the appellant still has the burden of persuasion here, just like they would have the burden if they were making an application for the first time to the CEO to show that they have the right to do what they're trying to do. But your job here is to take the facts as you determine them, apply them to your own interpretation of the ordinance, and determine whether or not, based on those facts and the ordinances, whether or not a permit could issue. Because this is de novo, the result of that will be a decision from the board with findings of fact and conclusions of law, and you'll either be granting the appeal, denying the appeal, or potentially, if sometimes you might remand it back to the CEO. But generally, you're going to be deciding afresh whether or not to have that permit issued or not. And if you have any questions about kind of the scope of the review here, happy to talk through them, but just wanted to set the table with that. That said, I think there is a key issue here for the board to work through, which is this access to lots question. The appellant and the town have provided you with their own glosses on what this language in 7.21 means and how it applies to this application. So I would say that's a good place for you guys to start, to talk through your own view on what that ordinance provision means and what it might mean for this application here.
Thank you.
No problem.
So, still kind of, even though I'm probably not talking about access to the lots, it essentially is where, to me, these are grandfathered lots. And at what point in time do grandfathered lots, all of a sudden, you could build on them, and now you can't build on them because we've added extra rules and regulations? I understand that it happens, but it just, that's kind of frustrating to me. Where it really comes into play is, so I'll go back to access. I'm not in favor of spurs off spurs off spurs. I don't think that's the intent of these words. I think the intent of the words are what the town mentioned, and that is that you come off a main road, and whatever road comes off that, you get three. You can put 3 little roads off there if you want, but you're gonna, you come up and put 3 little roads off, but you're only gonna put 2 houses on that whole spur. And you can put 2 on, but the minute you put the 3rd on, you're gonna have to get to the road standards. I understand the words are confusing, but I think the town's always interpreted it that way. It's my understanding that's the way it was. I've been in the town now 35 years or something like that, and That's always been my understanding of what the intent of those words were.
I agree. I have been familiar with the history of this and why it was put in and why it was written in. And I agree, this is really confusing. I think this is horrible for the people who bought into this, and this other now person somewhere down the line. I feel like some kind of clarification needs to be made somehow, so that landowners can't keep selling this to people, without telling them that they have to follow the standards, which are building a road to town standards.
Like false advertising.
Yeah.
Like, empty
And
promises.
granted, it's due diligence, and I think the whole thing with the CEO okaying it, I mean, that's really unfortunate, and I know that doesn't help your pocketbook or your dreams. But I believe that we need to stick with what the standards are, and Birchcroft has had a lot of houses on it, and I think it's time that it didn't have any more, because it's not following the rules of the town. And I think that now that if we can really clarify and show that this is how this needs to be interpreted, that it will also take care of future issues. So that's where I'm coming from.
Did you want to?
So, I think the comments are well taken, and you're getting to the nub of the question here, which is what does this language mean? And so I would just to kind of tease out, as a person who may be tasked with working up a decision here based on the discussion that you're having here, to kind of tease out some of these, why you're interpreting this language one way or another. So the appellant's attorney has stated that the way that they interpret this provision is that it should apply to new roads to be constructed that are to be accepted as town ways. The town has, I think, taken a position that access to lots refers to all of the access ways that would come up from the town way, and that the road standards would apply to any access way if the number of dwellings until you get to that public way is 3 or more. But I was wondering if you had any, if there's any what your thoughts were of that alternate interpretation, that this should only relate to roads that are being offered up for acceptance as town ways. Do you guys have any thoughts on that?
How it refer. So
Let me, while you
go ahead.
I think we've opened up Pandora's box a little bit with one of the new rules that they're not going to accept any roads now, subdivisions. The town's not going to take on roads, and they'll never be public roads unless they're a through road. I don't think the words have maybe reflected that new change as well. And so I think the town needs to go back and look at what they've done to the ordinance and how it does reflect with the road standards. But the road standards have always been, we've always taken the road standards to be what you needed to do if you were going to put a third house. And whether it was going to be accepted by the town. I understand what the standards say on the top, but it's always been, the understanding is, to me, that once you put the third house in there, there's always now the potential for it to become a town road, and as you start to add more on, you want to have it at least be able to be approved, because once you do it halfway, you know, if you just pave a driveway up through there, and then it has to be a town standard, you gotta tear the driveway back out to actually put it to town standards. So that, I think that was the intent, my understanding, the intent of referring back to the town standards,
Okay.
the road standards.
So what I'm hearing from Mr. Chair is that, so the language here, you know, refers to 3 or more dwelling units, and then states that the town of Berwick road construction standards are the standards that would relate to that. It sounds like you're saying, you know, based on how you read that language and the road standards themselves, you're saying that your view is that the road standards would be applicable whether or not the road was being offered up for acceptance, and the substantive standards would apply regardless of whether it was being offered for acceptance. It would certainly be required if it were being offered up, but it sounds like you're saying that you interpret this language to apply any time you have 3 or more dwelling units
Yes, I agree.
Yes.
off of some access way that is not a town
Yeah,
way.
if that was added to this, but that's not what this says. But if that was added to this, then you could directly apply it. Or easily, I guess, to me.
So one other thing that I just wanted to note, I think toward the end of the appellant's remarks, they pointed out that this last sentence in the note, access to lots refers to any streets, roads, or right-of-ways utilized to access the lot. And he noted that streets there, as is defined in the ordinance, seems to refer to existing public ways. I will step back and say, your job here, part of what you're doing is interpreting these ordinances, right? If in your view the language is unambiguous and the meaning of the ordinance is plain on its face, what you do in that instance, the courts have said, is you just apply the plain language, right? If the ordinance is susceptible to more than one reasonable interpretation, right, we call that an ambiguous provision. If the provision is ambiguous, that's where the real work comes in of trying to figure out, well, if there's more than one reasonable definition here, what is it actually saying and what is it trying to say? And that's when you have to reach a little bit deeper into the toolbox to look at the rest of the structure of the ordinance, looking at things like rules of construction, right? So one of the things that lawyers are instructed to look out for interpreting provisions is avoiding absurd results from language, and also being consistent, trying to give every word its meaning as well. So I guess to take a step back, in your view, is this language, would you say that the meaning is plain on the face of the document, or that this language is ambiguous and requires more context to have a clear understanding of what it means?
I think
It needs more context to further apply it.
it's ambiguous.
And it has to speak to lots of record from before 1987 to date.
And
To me, this was done back then, and you can't apply new rules to things that it's already held.
And I think it's important to look at the history of how it has been applied and how it was intended. And in that way, it was used as starting at I don't know what you call it, but a town road. So I don't know.
Yes, I think that's what you mean.
I think if that, you can clarify it like that.
In the example that we're putting forward, it would be Little River Road. That would be
Right.
the town road.
Right.
That's what you've always felt
Yes,
these ambiguous words meant.
right.
So
Starting there.
So effectively, access to lots would mean access to lots from the nearest town or public way, essentially.
I don't know how you'd word
We'd
it.
clear it up.
Yeah.
That would make it
Yes.
black and white.
Any different views on that? Haven't heard. I'm sorry. I'm bad with names. Is it Ernie?
I have not lived in Berwick that long, so one of the things that I've learned about being on this board is that I have to pay attention to fact rather than opinion. There are lots of opinions about lots of issues. The question is, can a person or entity make a presentation that has factual information that can be interpreted as factual? And that's how I view things until I learn more about the history of Berwick and also past instances in which we had to make decisions based on facts rather than opinions.
Okay.
Now, I do want to circle back to this discontinued road issue, because I'm still not convinced that, I understand what the words say. It says discontinued road. But I don't understand what the difference between a discontinued road, in a sense, and there's no definition in the ordinance, and a right-of-way that has legally grandfathered lots that they could build on. I'm really struggling with why they don't, it doesn't.
Do you want
Doesn't
his
speak to
opinion? Or do you
No,
want
I'm just
All
talking
right,
about us.
well, I have an opinion about that. And that is that there are many, Berwick is an old town, and we have many roads in Berwick that used to continue on, and now they don't anymore. One of them is Lovesbrook Road. It used to be Old Blackberry Hill Road. Another one is Lower Cranberry Meadow Road. Those are two I'm familiar with because they're in my neighborhood.
Knox Lane.
I don't know about it.
It goes out.
So those are discontinued roads, and over the years, people have worked to build them or whatever, do whatever. It's always been that they have to bring them up to the standards. And for example, I don't think Blackberry Hill Road or Old Blackberry Hill Road has an easement. I don't know that, but I know that there's definitely an easement on the Lower Cranberry Meadow Road. And I think, so that's one instance. But I think the two things are different. And when this was just, put into writing, I believe that this is specifically talking about those discontinued roads. And I think there's a list in Berwick of what the discontinued roads are. I mean, I think that's a list that exists. And so a discontinued road is definitely not a private road that, maybe has lots that are, of record or whatever, no. A discontinued road is a special entity of its own. And that, I don't know legally, but I know historically that's kind of where that comes from.
We're looking here, nothing speaks directly to the private road, so what else do you apply? What do you apply to
You
it?
have
Because
to-
all it gives us is rules for a road the town doesn't take care of anymore, or one that they never did.
Right, so
me-
it doesn't count. So you don't apply it in this situation because it's not a discontinued road. So you don't,
But
it doesn't fall in that category.
the ordinance doesn't speak to a private road differently, so it doesn't, as if there's a different set of instructions or rules. If you think if the rules were different for a private road, I would think you would say if it's a private road, you need this. If it's discontinued, you need that. But it doesn't speak to it. So to me, it's not a town road. It's
But
a,
is the private road really any different than any other dirt road off of a main road? Like,
non-town owned dirt road. Is it our?
yeah, I guess, like if Little River Road is our town road and Birchcroft Lane is off there, well, maybe down the street a little bit, I don't know the area very well, down the street a little bit, there's another dirt road off there, you know, not Birchcroft, but a whole nother
The
one.
next one, yeah.
You know, I mean, whether it's a, you know, a driveway, a private road, whatever, you know, they follow this. They are not a discontinued road. It's,
Because
the
they're new.
private roads follow this. A special dispensation has been made for a discontinued road. They're two different things.
I guess where I'm coming, it's not them being two different things. It's the intent that they specifically said, if you were a grandfathered lot, you could build, if you had a grandfathered lot, you could build on a discontinued road. These are two grandfathered lots.
But it's not a discontinued road.
I don't know, there's no definition in here on a discontinued road in this ordinance.
Well, look back in your town history and see if it's a discontinued road.
I can only go by what's in this ordinance right here, and there's nothing that says, tells me exactly what a discontinued road is.
I understand that.
I'm just, you know, I'm not trying to get adversarial, I'm just
Right,
trying
but
to,
I'm saying,
that's
you know-
where I'm really struggling with, you know, we're not talking about someone, you know, cutting a road through the woods,
New.
No.
brand new, and cutting out 2 lots, or 3 lots, and saying, well, now, I've got 3 lots, I don't have to pave it, because they're brand new lots, they aren't grandfathered. And like Ashton mentioned, and I think the lawyer mentioned, it seems pretty interesting that it was done the day before the date in this ordinance. So they
That-
must have come to the town
Everybody did it.
somewhere along the way and got some guidance that this was a legal thing to do at that point in time. We don't know. I wasn't here, you know,
Well,
on the board.
some of us
then.
were, and that was what happened. People would hear that an ordinance was coming in, and they would quickly throw together what they thought was going to work and get it done and hope for the best. You know, I mean, it was like somebody said, there are 187 of these or something, whatever, I don't know. But I don't know if that's relevant
So
at this point, you know, what we're talking about.
No,
you guys get to credit the relevance, but I did want to point out, so on the specific question of, you know, what does discontinued road mean in this context, I would point out that there's a following subsection, so it's big A, at least in
What
the
page
version
you're on?
I have. So this is page 67.
Oh, okay.
So 7.21.
Oh, big A. Yeah.
So after that language about more than 2 dwelling units, it does say the lot is the previous sentence, 1 dwelling unit shall be allowed per lot of record with an additional dwelling unit. And an additional dwelling unit shall be allowed per lot of record, provided that the lot is surveyed by a state of Maine registered surveyor and recorded in the York County Registry of Deeds with the following provisions. The discontinued road is not maintained or plowed by the town of Berwick. Any upgrading or plowing of the discontinued road will be at the expense of the lot owner. So I think, you know, they continue to use the term discontinued road there. I think, you know, it would be fair to infer from that language that we are talking about a road that previously the town had responsibility for maintenance for. And, you know, so we have language here talking about that the town is not responsible for doing that anymore by virtue of it being a discontinued road, which is a legal term of art in the state of Maine. A road being formally discontinued is something that, even if it's not defined in your ordinances, that is certainly something that it means a certain thing under state law, certainly. And the key distinction there being that at one point, the road, the accessway was town-owned and town-maintained. So it was not something that the individual lot owners would have been responsible for undertaking the maintenance or care of while it was in the way. Once it's discontinued, obviously that's no longer the case, but that would be the difference if we're looking at a discontinued road at one time was the responsibility for the town to maintain.
Birchcroft Lane is a discontinued road. If it was, and you had this exact one, would this be no question approved? Approved to build? If it was a discontinued road?
So
Lots of record previous to.
So I think you'd have to
1487.
you'd have to look at the language, right?
If it-
And so if it met the so if it were, let's say hypothetically that it was a discontinued road for lots that were created before March 14th. then this provision says that more than 2 dwelling units may be allowed, provided that the road is brought up to the standards for 2 dwelling units as described above. So you'd have to look and determine whether or not that road met that applicable standard, right? But it is, I think the straightforward reading of that is yeah, if you have a discontinued road, then a different standard may apply.
Right. So in my brain, where this does not speak to the private roads, I feel like I don't have a choice but to apply the discontinued road stuff to the private road, and that's my position. So,
Yeah, I understand that. But I don't understand why you have to go to that point when you have the table to refer to.
So then it comes to it needs to be 2 dwelling unit, like this says, 2 dwelling, 15 wide, 15 deep. I have no idea what Birchcroft Lane's condition is that way, because in applying it, if we applied it that way, if we imagined that discontinued road or private road prior to 1487, then it kicks us up to the 2 dwelling unit one, 2 dwelling unit standard.
But if
So,
you don't,
and that's-
if you don't
we haven't
have the
touched that whatsoever.
discontinued road one, then you keep going down and you apply the 3 or more dwelling one.
Well, we wouldn't, I
It
think.
doesn't
what-
matter, it's not what we're considering right now, does it? I mean, do we have to rehash that, or?
Well, I think,
No.
Or is that-
no, I
do
think
we-
we're
do
all
we-
set on that. I think
Yeah.
the question is does that note that you can have, if you're a grandfathered lot, if you can build on it? I think that's what the question is.
Yep. And
And it's, the question is that a discontinued road, does it meet the definition of a discontinued road in someone's opinion or not?
no, it doesn't meet the definition, but there's not a definition for a private road, so I have no other
Yeah, but-
option than to apply the discontinued road instructions.
I think that's a stretch. I
There's
realize that there's nothing
Is there anything
there,
is there something specific to
But-
private roads? And we have a lot of record,
but then it just.
lots of
follows
record, I
the
should say.
table. These are only specifics, these are specifics that apply. And if your specific, if your thing does not fit the specific, then this whole section doesn't apply.
And so I think, and I'm sorry, forgive me,
Yeah.
I don't know your name.
Pat.
Pat. So I think, Pat, what I'm hearing you say is that if this is not a discontinued road, then what you would default to is the table.
Yes, that's what I'm saying.
And the table would set out the standard based on the number of dwelling units that are being constructed on
Thank
that
you.
access way. Is I think what I'm hearing you
That's
say.
what I'm
Pat.
trying to say.
Yeah, well, I think if that note wasn't there, we would be at that table. Right? I mean, if that note wasn't there at all, we'd go back to the table, we'd be pretty clear, cut and dry. It's just that someone decided way back in the beginning to stick this note in there that said that if it's discontinued, you can build on it if you have a grandfathered lot. So,
But you don't understand that that's a whole different situation where roads are have already been
I know,
built up in certain ways, so they had to deal with it because of that. Okay, that's all right, it doesn't matter.
No,
It doesn't-
I think, I know what you're
It
saying.
is by default to the table.
I think that it's still relevant, it's just determining whether it is a discontinued road or if it meets the intent of it. And if we don't think it meets the intent of a discontinued road, then it doesn't apply.
Okay. So, I guess I'd like to hear from you guys then. In your view, does that paragraph apply to the facts here? Does the access way that we're referring to, which it sounds like there's consensus here that we're talking about Birchcroft as well as the spur, I believe is how you're referring to that.
Right.
I think the question that I would pose to the board then is, in your view, does this, based on, kind of what I've described about what a discontinued road means under state law and your own interpretation, does this access way meet that, fall under that provision from your point of view?
Right.
And I'm asking.
Yeah, I know, I'm confirming that's what you're
Okay,
asking.
yeah.
Well, I've given my opinion.
So it sounds like Pat is saying no.
Unfortunately, I want to say yes, but I don't think it does either. I mean, it's frustrating because I think that at the time, if we'd have talked about it, the wording could have changed, but, could have been put in more clearly, just like we talked about the other language could have been more clear. But I don't think that Birchcroft Lane, unfortunately, was ever a discontinued road. It's as frustrating as it is to me.
And I can't see your name tag, I'm so
Ashton.
sorry. Ashton. And what would your view be, Ashton?
That there's not specific instructions for the private road, so that makes me apply these instructions to the lot of record.
So are you saying in your view that paragraph would apply to this case?
Yeah, that's what I'm saying, is, yes, it's a pre-existing lot before that date. Nothing, it doesn't say it only lists discontinued road, but nothing else speaks to private road. So I'm not sure what else I'm supposed to apply to a private road. Like, this was done back then, in time for the ordinance to come out it appears to be a legitimate surveyor and whatnot, and I haven't held the deed in my hand out of the folder in Alfred or wherever, but to me it was created back then so that it could be built upon one day, and enacting this stuff later on, I don't think that it should knock down lots that were already established. They just shouldn't build on it before this was enacted.
I don't think it knocks down the ability for the lots to be built.
Mhm.
That they can build on those lots,
Mhm.
but they have to follow the access.
Which is
Not doable.
overly feasible.
Which is the default for the table.
And Ernie, do you have a view on so what's being discussed right now is whether this paragraph that carves out an exception for discontinued roads, whether that applies to the access ways that you're talking about tonight.
I have to get more education on that piece because I'm hearing a lot of, and I have to discern facts from opinion. And that's going to take some time for me to sort the facts out as I see them and the opinions of people. Difficult for me because I don't know the background. I don't know the history. I could take a stab, but that's not professional.
So I feel like at this time we all have our position. We know which way we're going to vote. So someone needs to make a motion one way or the other. Is there closing? Is there one more?
Well,
By right of steps, is there one more?
Well, so I think and I don't want to drag this on for longer than it already has here, but I think you were discussing what language is applicable to the project here, and then you'd have to determine whether or not it meets those provisions. What I've heard two of you say, in your view, the table is what would control here, specifically the third item on the table. This is simply a private road, so you would apply the general rule that for 3 or more dwelling units, the town of Berwick road construction standards would apply. I've heard from Ashton saying, in his view, this is, I think, I don't want to speak for you, but effectively a discontinued road, even if it is not one necessarily in fact or by law. And that therefore the provisions in that paragraph would apply. And I think Ernie has not provided a position one way or the other on that. So it sounds like there's kind of a 2 to 1 to 1 right now on where that is. Ultimately, a decision that the board reaches has to, a majority of the board would have to agree to a decision. In the case of a tie, generally because the applicant bears the burden here, a tie would generally result in a denial of the appeal at the end, right? So if there were two people who were saying that the appeal should be granted and two saying it should be denied, generally speaking, the tie would default to a denial here. So I think it sounds like there's a bit of a stalemate on this specific question of whether that provision applies. I think if we take a step back and say, let's assume for the moment that it does not, okay? If it does not, then is the board's view, so I'm going to challenge you the hypothetical here. If we assume that what we need to be looking at is the language in the table, is there a consensus that in that scenario, you would need to apply the road standards to this project?
Yes.
Yeah.
So if we were applying it right to the table, yes.
Yes.
Okay. So, and if the paragraphs below applied, is there consensus that you would then be applying the second item on the table here, which would relate to two dwelling units
Yes,
and not three? So
if this applied, then that's where we would be.
Ashton's position.
right. So in a world where we're dealing with a discontinued road, whatever that might mean in that section, I think you can all agree that the second item on the table would apply there, right?
If it was a discontinued road.
Right.
Now that okay, yes, that's what the words say.
Yes. So it sounds like, and there would be, I think, if you did determine that the CEO applied the third item on the table here, right, and determined that this road was not up to those standards. I think if you determined that, well, actually, we need to look at the second prong, the follow-up question would be, well, does it meet those standards? But it sounds like you gotta reach a consensus on
The discontinued.
on this question of which applies here, and is this a private way that would serve three or more dwelling units, and therefore that the road standards would apply, or that this is that the paragraph below the table applies, this is a discontinued road for the purposes of that paragraph, and therefore we're looking at the second item on the table.
And by the words that are there, you can't apply what mine's. With the words that are here, I can't, by the black and white of the page, apply what I'm trying to say. But the way it feels to me, it's opinion doesn't matter. But I think where it's already done, I think it doesn't matter. This does say discontinued road, so that ties against what I want, I guess, or how I feel, what my opinion is.
Or what you think the intent of the words are.
And you're entitled to disagree.
Right, yeah, absolutely. Yep.
yeah,
I don't have to vote the same as everyone else. That's fine.
Okay, so I have, I think, a clear sense of, if the board, if you determine that this is a project for which the road standards apply, then it sounds like there would be consensus that the appeal would have to be denied then, because this road, based on the evidence you've heard, does not meet the road standards.
Right.
On the other hand, if it were if the two dwelling unit standards applied, then you may have to have some more discussion about whether those standards are met here.
Yes.
I think that's where we're at.
Yes.
A couple things we can do here. I could, I think I have heard two definitive members state their position in on one side of this. I've heard one member state a firm position on the other side, and Ernie, I would look to you to, I know that this can be a difficult task, but the job of this board is to, take the facts as you hear them and apply your own, look at the language of the ordinance and from your view determine what that language means. So if you do have any thoughts on where you fall on this, that would be helpful as I move ahead to hopefully draft up proposed findings and conclusions for you guys to vote on at your next meeting.
Want me to speak to that?
Absolutely.
I would agree with I would side with the first interpretation if I had to make that decision, based on what I'm seeing in front of me in terms of the ordinances, et cetera. And it's difficult. It's a difficult decision, but I think that for me, it would be the best decision only because it seems to have the most facts involved rather than the opinions.
Okay. And so from your view, you're saying that based on your reading right now, you're saying the first interpretation being what Pat and the chair Rick have stated that so your view would be that the road standards would apply to this because it is not a discontinued road.
Correct.
Okay. All right. So if that is the case, I think I'm hearing 3 members fall on that side of this issue. Again, we do not need unanimity here. All of you are entitled to fall on this, and ultimately a final decision does not need to be a unanimous decision. The written findings will reflect the majority view of the board, and that is totally fine to do. So what I am hearing, though, is a majority view that the best interpretation of this language is that the town's road standards do apply, and that based on the facts that you have heard here, including the fact that Birchcroft is currently a graveled road, it is not paved, and I think the appellants have conceded that the road standards are not currently met. It would require potentially millions of dollars to bring this up to those standards. Based on those factors, it sounds like the result of that would be a denial of the appeal, based on the applicability of those standards and the fact that the standards have not been met. So that's what I'm hearing. What I would recommend for a next step would be to authorize me to work up draft findings that reflect the discussion that I just heard all of you go through, and to work up the findings and conclusions based on that, I think, working majority view of where this should fall. And then I would present that draft decision to you at a continued meeting for you to look at, discuss, determine whether or not that reflects your own views, and then vote on adopting either that decision or some changed decision from there. That would be my recommended course of action here.
Sounds reasonable.
Yeah, it sounds like exactly what needs to happen.
Yep.
Sounds good.
And so now that the hearing has been closed, you have 30 days to make a decision. Obviously, ideally, it's going to be much sooner than that. But once you cast a formal vote to approve or deny the appeal, by law, a written decision must issue within 7 days.
Right.
So for that reason, I would recommend that you hold off on formally voting to approve or deny the appeal until you've had a chance to look at the draft findings and adopt those findings.
Okay.
That would be my recommended order of operations here. In that case, I would look for a motion to authorize me to draft a draft decision for your review at your next meeting.
So moved. Second?
Second, third, yes.
No, I didn't say it.
All in favor?
Okay. So I will do that then. So from here, I think you can safely continue that appeal I am looking at the clock, it's exactly 8:30. So I would defer to the chair as to how you'd want to proceed from there. But that appeal is technically still open. It will be open until a formal vote is taken to approve or deny the appeal, which now has to happen within 30 days.
Very well.
Do you want to, how long do you think it's going to take? So, trying to gauge when we want to schedule the next meeting.
Yeah, I will, I am happy to work as quickly as I need to.
Sure.
To accommodate the board. So if the board wants to meet next week, then I would do my best to, I would have a decision for you in advance of that meeting. 2 weeks would be easier. Certainly no more than 2 weeks would be required. But if the board wanted to meet next week, if that were what you were gearing up to do, I can work with that.
I don't have a calendar in front of me, but I don't foresee any issues. I don't have any planned vacations in the next 2 weeks. So.
And I would also, you can potentially ask the appellants when they would next be available as well.
Yes, yeah.
Does 2 weeks seem,
One or
Would it
two.
be a Wednesday evening?
that's typical when we meet, yes.
I could be available either the 22nd or the 29th. So I'm at your pleasure.
Can we do the 22nd?
That'd be 7 days from now.
Is that okay?
We'll make a motion to make our next meeting on the 22nd of October.
That work for the town?
Should be fine, yeah.
We also mentioned that we were going to adjourn at 8:30. Are we going to continue the items on the agenda at that meeting? Is that the way we should legally do that? I'm not entirely sure.
So you can do a couple of things here. You can ask the appellants how they would want to proceed. If they would have an issue with continuing the next two items on the agenda to that if they want to be heard tonight, then I think we could take it back and you could discuss whether or not you wanted to do that. But under your ordinance, you have
30 days, 45 days
from the date of the appeal, I believe.
from the date of the appeal.
So as long as you fall inside of that timeline, you can do what you want.
Right.
I would say if you fall outside of that timeline, then you would want to get their consent.
Right. What,
Would we want, sorry, would we want to?
Are you going to
So-
do ours next time too?
yes, on the 22nd, if that would be something that,
Are we thinking we're actually going to hear us on the 22nd? Just honestly,
I think they would be the next item on the agenda, I believe.
Yes.
Okay. Yeah, that's fine.
I think we're all in agreement. Did you make a motion to that then?
Yes. There you go. 22nd, correct?
Works for me.
Okay,
That'd be at 6:30.
yes.
Okay.
So we'll do the findings of facts and the signing for this, and
Start,
we're going to continue with
continue with the agenda.
West Meadows.
Yes.
And counsel, I will once that draft decision is drafted, I'll furnish you with a copy as well.
Thank you.
I think you've decided on a meeting for the next time. I need a motion to adjourn.
I make a motion to adjourn.
Second. All in favor? Meeting adjourned.